Okay, well, hello, everyone. Welcome to our panel on legal challenges to parody. Got some fantastic guests today. I'd like to introduce Nicholas Wallace, who was a Stanford University Law student who is now a graduate. Nicholas created a satirical flyer that went viral called the Originalist Case for Insurrection, that a member of the Stanford chapter of the Federalist Society did not take too kindly to, and led to him nearly not graduating on time. And we'll hear a little more about that in just a moment. We've also got with us Roslyn A, also known as the patron saint of editorial cartooning. Roslyn was counsel to the AAEC as a friend of the court in Hustler versus Falwell. And the fact that we can all create works of parody today is largely thanks to her, at least with, a certain degree of legal safety. With us also is Shawn Musgrave. Shawn is a First Amendment fellow at the Center for Investigative Reporting and a recent graduate of Stanford Law School who assisted Nicholas with his situation. Now, I want to just mention why I wanted to have this panel in the first place. I feel like as cartoonists, there are a lot of things that get talked about, in terms of freedom of the press and freedom of expression. But I think it has been under discussed, these recent legal challenges and lawsuits, or maybe not going as far as a lawsuit, but just these threats to satirists. And especially, I see this as even, a growing threat as the US seems to be going in a more authoritarian direction. So I'd like to get our panel of experts weighing in on this. We are lawyered up today. And so we've got an army of lawyers to answer all your questions. So to get started, why don't we have you, Nicholas, just tell your story for people who haven't heard it, who aren't familiar with your case.
Yeah, thanks so much, Jen, and thanks to all of you for having me. I'm super excited to be participating in this panel with all of you. And in classic lawyer fashion, I have to begin with some legal jargon and a disclaimer because I'm a government employee as of a month ago. So I have to say, any views expressed are mine alone. They do not necessarily represent the views of the government or of the commission that I work for. Okay, so with that being said, I think it would be helpful to start with a little bit of background on this organization that was the target of my satirical flyer. It's an organization called the Federalist Society, which I'm sure most of you have heard of. And if you have heard of it, it's probably in the context of them kind of being a kingmaker in judicial nominations. And at least during the Trump administration, they kind of, whichever name they gave to President Trump was the person who would get nominated, which included Amy Coney Barrett and some other Supreme Court nominations, basically just got handed down from the Federalist Society. At law schools, the Federalist Society plays a little bit of a different role, and they kind of cast themselves as a conservative debate club that hosts these kind of intellectual debates and conversations about challenging and novel legal ideas. And they host a ton of events. They have an event basically every week at most law school campuses. And they really, at least, during my time in law school, they really kind of dominate the intellectual conversation happening day in and day out at a law school. So they're very prominent. They get a lot of really kind of big name speakers and judges and Supreme Court justices. So that's kind of the background for this organization that was the target of my flyer. So the other relevant piece of information is that in January and leading up to January, a lot of Federalist Society figures and members and leaders were very involved in first the movement to cast doubt on the election and spread what's come to be known as the big lie. And then on January 6th itself, the Federalist Society had several members who were there on the stage with Donald Trump immediately before the mob stormed the Capitol, and they were there kind of urging them on. And politicians like Josh Hawley and Ted Cruz, who kind of lent support to the mob as well, are also kind of alums of the Federalist Society. So they were kind of all up in the whole thing. And then after the insurrection, a lot of people thought that this organization, which cast themselves as defenders of the rule of law and defenders of the Constitution, might have something to say about the insurrection and might want to say, we're actually not on board with insurrection. That's not our thing. We don't support our members who did that. We don't support the members of our leadership who were involved in that. But instead, the Federalist Society remained totally silent. They didn't put out any kind of statement. They didn't respond to any of the criticism. And on the law school campus, there is kind of a growing fervor, like asking, what is this organization? What are they doing on our campus? Why are we putting up with them? There's a lot of anger and a lot of frustration. And the Stanford administration kind of stepped in to say, we support free speech on this campus, and we're not going to take any kind of action against this organization. So stop emailing us about them, stop complaining about them. Like, we're done with this. And that was about 3 weeks after the insurrection. And that is when I sent my flyer to a student listserv. That's kind of the role of the listserv. Yeah, and there you see it. The role of the listserv is kind of the main thing it's for is people who are like advertising like furniture and looking for legal advice and that kind of thing. But it's also where people kind of spout their political arguments. And so the format for the flyer is directly taken from the format that the Stanford Federalist Society uses for all of their events. So they always have the pictures of the guests and the name of the event, and then a little description. So I basically just mimicked exactly the way they were to advertise an event. But the two pictures you see there is Ken Paxton, a Federalist Society alum, who's the AG of Texas. That's him speaking the day of the insurrection on the stage with Donald Trump. And then the other picture is Josh Hawley raising his fist in support to the mob that's about to storm the Capitol. And the joke here is the originalist case for inciting insurrection. Originalism is kind of like the religion of the Federalist Society. It's kind of their founding core belief that the Constitution should be interpreted in the same way it would have been interpreted by the founding fathers when it was written. So to understand the Constitution, you have to go back and look at their notes and their thoughts at the time, and you have to look at James Madison's, his diary and everything that he believed in when the Constitution was being drafted. So that's the flyer. I sent it out. There's a lot of kind of hubbub on campus, a lot of email follow-ups from students. For the first immediate response was from a few students who were like, wait a minute, what is this? Is this real? Like, what the heck is going on here? And then there are some students who said, this is in really poor taste, like insurrection is not a joke. Why are you joking about it? And then that kind of kicked off a follow-up conversation about the Federalist Society, but also there was a really interesting conversation about Parody itself, with students kind of chiming in to say, Parody actually has an important role to play in kind of furthering political conversations like this one. So we're sorry that some of you are uncomfortable, but like, you should be uncomfortable because there was an insurrection 3 weeks ago and an organization on our campus has a bunch of connections to it and nobody's talking about it. And then it kind of, the conversation on the email kind of died off after a day or two. And that was about it for a good 5 months. And then on literally my last day of classes as a student at Stanford Law School, I get a notice from the university saying that I am under investigation for a violation of something called the fundamental standard, which I had never heard of until that very moment. And with the notice, there's kind of a long document that explained kind of my rights in this investigation and how the investigation would unfold. And then there's a link to an online folder with all of the investigation's documents. And the only document in this folder was a letter authored by the officers of the Stanford Federalist Society. And the letter, it's really a masterpiece of kind of dodging around reality. What the letter was sent to the administration, and it said basically that I had impersonated the Stanford Federalist Society, that I had, in impersonating them, I had harmed their reputations. And the best part of the letter was they said that I had defamed Josh Hawley and Ken Paxton by sending this email. So their basic claim, they had two basic claims, which was one, that I had impersonated them, and two, that I had defamed them. So I received this notice of the investigation, and it turns out with these investigations, they put a hold on your diploma if you're about to graduate. So I'm heading into my last finals week and 2 weeks until graduation, and I'm being told that I can't graduate if I can't get out from under this investigation. So what ensued was, and this is where Shawn comes in. Shawn should also have a little halo, at least a personal halo for me, because Shawn and I were good friends at school, and Shawn is a First Amendment expert, and he was one of the first people I called when I got this notice. And he immediately pointed out that, like, parody, there's legal protections for parody, like that's free speech, it's political speech. The school probably can't punish students for this kind of thing. And he helped me kind of navigate this administrative process, and we put in calls to different administrators saying this complaint against me is retaliatory. They're just trying to get back at me for this flyer that embarrassed them, and it's totally inappropriate. It's a total cynical misuse of the administration's process, and this needs to stop. So we tried to like tell some administrators to end this right away, and nobody would really listen to us. That kind of the response was just, you need to go through the process. So finally, Shawn put me in touch with this organization called the Foundation for Individual Rights in Education, and they put together a press release and a really amazing letter to the Stanford administration that actually cited Hustler v. Falwell, which we'll talk about in a little bit. It's kind of saying, hey, Stanford, this is what parody is, and it's very, very constitutionally protected. So you need to drop this investigation. They still wouldn't listen. So finally Fire put out this press release, and the media picked it up. Slate picked it up first, and then the New York Times and the Washington Post. And Stanford had a change of heart, and they realized that it was protected speech, and they dropped their investigation. So I guess I'll leave it there. Shawn was also involved. So Shawn, if I've missed anything important, yeah, feel free to chime in.
Yeah, one of the just the only real like legal point that should be emphasized is that California has a kind of a bridge, a legal bridge from the First Amendment to Nick's rights as a student at a private university. So I think Roslyn could go over this much better than I could, but effectively the First Amendment only protects you from the government. Private actors typically are able to do whatever that they want to you, basically concerning your speech, including private universities in every state that I know of, except for California. California, though, has a law that applies the First Amendment to private educational institutions, except for like sectarian religious ones. It's called the Leonard Law. It's been in place for decades. Stanford's materials about the internal student disciplinary process talk about the Leonard Law all over the place. Since I had not even taken the bar at the time, Nick and I were navigating this. I wasn't obviously able to make very many legal arguments to them, but I would just cite their own materials back to them and just say, like, why is this not immediately why do you think that you're able to do this given the Leonard Law? They just wouldn't really respond to those arguments. So I mean, that's just to say for any kind of nitpickers who might be thinking like, well, Stanford could do anything that they want because they're not a government body. In California, functionally they are. Stanford had to, or not that they're a government body, but Stanford and other private educational institutions in California have to follow the First Amendment, which is what made their position ridiculous. One of the funnier things at the end of this process, funny/sad, at the kind of the tail end of everything that happened to Nick, was that Stanford lawyered up, got an outside attorney to apparently take a second pass at all of this, and their outside attorney apparently thought that this was a close call. The
only attorney who thought that.
The only attorney. I mean, I contacted several First Amendment. I got plugged into various people in the First Amendment community, lawyers who are on the Stanford faculty, as well as some of the non-lawyer members of the kind of the faculty senate at Stanford. And they all took a look at this and were just like, this is parody. Like, this is whether as a legal, whether you're thinking through a legal lens or just kind of a lay lens, like this is kind of all the hallmarks of being satire. And yet Stanford still put Nick through this process, which, as I kind of walked away from this with worries about how other institutions that are like clearly not covered by the First Amendment might treat people in a similar position as Nick. I know there's another situation unfolding right now at Emerson College, which FIRE is involved in, involving some students who put together some very controversial stickers about China. There's no First Amendment protections for them whatsoever. Whatever you think of the message that they're spreading, which is controversial, and I don't know if I'd want to wear one of their stickers, but if they were at a public university, they would be protected. They're at Emerson College in Massachusetts, so they're not, whereas they would be in California.
Well, Nick, that whole ordeal sounds very stressful, and thank you for sharing that with us. I have to compliment you on your sense of humor. I think that flyer was very well written, and I'm curious who your influences are. Any?
Well, since this is a panel of cartoonists, I have to say that Bill Watterson is a huge influence on me, and Calvin, Bill Watterson, creator of Calvin and Hobbes. Calvin is perhaps one of the reasons I've always been a little bit of a troublemaker in the classroom environment. So that's one.
Well, I think, yes, I grew up on Calvin as well. Big influence on me. Before we go to Roslyn, I would like to mention another case that all of this reminds me of, and that is the case of Devin Nunes' cow. Now, we tried to book Ms. Cow for this panel, but very sadly did not get a response. I believe she was out to pasture, and sorry. I think she's been through a lot of abuse though, so I almost can't blame her for laying low. But to summarize this case briefly, basically, California Representative Devin Nunes filed suit against this Twitter account, as well as other Twitter accounts, saying that that they were defaming him, and basically, there's just been like lots and lots of different judgments. In August this year, I guess Devin Nunes lost again. A Virginia judge dismissed two of the lawsuits, dismissing the Republican strategist Liz Mayer, who I'm not clear if she's behind the account or she's always mentioned in these lawsuits.
Separately,
separately.
I think Ms. Mayer, I don't know if Mayer has denied explicitly that she runs the account, but I know that
Right.
Ms. Cow herself has certainly said that they're separate entities.
Okay. And I guess he sued Twitter as well, and anonymous writers who heckled him there was another account that posed as his mother. But basically, this cow has been through a lot, and I can imagine that whoever is running the account, it's been pretty stressful for them, and they have had to retain attorneys, and it's taken up a lot of their life over the past few years. So, Roslyn, what do you have to say about these harassing lawsuits or threats of lawsuits?
Thanks, Jen, and thanks everyone for inviting me to join this great panel. It's wonderful to hear Nicholas's story and Shawn's efforts to help extricate him from a bad situation. So Jen asked me to chart a little bit of the history of this preeminent Supreme Court case that I was involved in 33 years ago. Hard to believe. So many of you know this case very, very well. Have heard me talk about it. I've heard Anne and Matt and many others who are attending the convention talk about this case. Jerry Falwell, the head of the moral majority, sued Hustler magazine over an ad parody, self-described ad parody back in 1987. JP, if you'd kindly bring up that parody. So this was a parody of the Campari liquor ad campaign, When Was Your First Time? And it depicted Jerry Falwell's first time being with his mother in an outhouse and what they did. And it went on from there. There is a disclaimer at the very bottom, ad parody, not to be taken seriously, but Reverend Falwell took it very seriously and sued for $100,000 in federal court in Lynchburg, Virginia, kind of one of the ground central of the moral majority. He advanced 3 claims: defamation, invasion of privacy, and intentional infliction of emotional distress. The first 2 claims went by the wayside on motions practice, but the intentional infliction of emotional distress under Virginia law was successful. And so he won a verdict for $100,000. He sued for much more, and then punitive damages on top of that. So the verdict of $200,000 went up to the Fourth Circuit Court of Appeals, which sustained the verdict in a 2-to-1 decision. The dissenter became very prominent in the Supreme Court's ultimate disposition of the case. But what is very interesting and historically notable is that at the time the case the Supreme Court agreed to take the case. This is in 1987. Knees were quaking among the First Amendment bar. Everyone was terrified that the Rehnquist court, a very, very conservative court, at the height of the influence of the moral majority, would use this case to revisit what was then a 23-year-old precedent, New York Times versus Sullivan, which of course extends significant protection to public officials and then to public figures, and an extension of the case in defending defamation claims. And the question in this case was whether that protection, that broad protection, would extend to this unusual other cause of action, intentional infliction of emotional distress. As many of you know, I was in private law practice at the time, and I made a presentation to the AAEC convention that spring, which happened to be meeting in Washington, and kind of sounded the alarm that this case presented a genuine legal threat to First Amendment protections for satirists and others. And so AAEC retained me to file a friend of the court brief, which is available online. And the brief contained an appendix of some 40 political cartoons going back to Thomas Nast and other English and French forebears of Nast. The thrust of the brief, and this was a strategic decision that I made in consultation with some of the great luminaries of editorial cartoondom, Patrick Oliphant, Jeff McNelly, Tony Auth, Draper Hill, just an amazing array of cartoonists who helped me strategize and figure out just how in the world we were going to persuade. We had our target on Rehnquist and Justice Scalia, the most conservative justices, to try to persuade them that liability for this cause of action, intentional infliction of emotional distress, could not survive First Amendment scrutiny without basically destroying parody, satire, and political cartoons. The story's been told. I've told it, others have told it. It's been recounted in a number of books and law journal articles. It turns out, and I had some hints of this when we were drafting the brief, Justice Rehnquist and Chief Justice Rehnquist and Justice Scalia both have fantastic senses of humor. They're also great students of history. And we appealed to that in our brief. As you know, the court unanimously reversed the judgment in favor of Reverend Falwell. It surprised everyone, including me. It was really a shocking decision and a resounding reaffirmation of the Times versus Sullivan actual malice standard. Over the years, over the 33 plus years since that decision, as I've been asked to recount the amusing and weird history of the case, I've tried to plow the ground and come up with some different information, different insights from different people. And one, just share these last 2 points. One fascinating insight that I learned before the 2012 convention of AAEC here in Washington was not only was Justice Rehnquist a fan of political cartoons, but if JP will oblige and put up this next visual, this next image, the yearbook from his high school in Shorewood, Wisconsin, contains the following entry about Bill Rehnquist. Quote, "The favorite pastime of Bill in and out of school is cartooning," unquote. And there you see a picture of Bill Rehnquist from his Wisconsin high school. So this was discovered by Roger Newman, and it's just one of the most fascinating pieces of information that we discovered. I'm looking forward to the time when Chief Justice's papers at the Hoover Institution at Stanford become available to the public. His notes and doodles from 1988, the term 1987-88 are not yet publicly available, but I'm hoping that there'll be more material to mine there. So that's a very brief synopsis of the case. And, scholars have pointed out that before Hustler versus Falwell, the Chief Justice Rehnquist was against the First Amendment position in over 80% of the First Amendment cases that had come before the court before that case. So the cards were really stacked against the positions we were advancing, but through the efforts of many of the forebears of today's cartoonists, we were able to win the day.
So, Roslyn, what do you, in light of that, what do you think about these recent cases with, Nicholas and Devin Nunes' cow?
Well, we were chatting in the practice session about the cold sweat I really have about the possibility that the Supreme Court will take a parody case in coming years, or a case involving satire of some kind. It's inevitable. I mean, they will do that. And so these cases worry me greatly because while you could say, oh, okay, there's a conservative court now, there was a conservative court in 1987, but the composition of the court and the disposition of some of the justices really concern me. I have some faith that in the lower courts, the trial courts and the courts of appeals will apply the Times v. Sullivan standard because it's precedent. But as we'll talk about a little later, both Justice Thomas and Justice Gorsuch in the last couple of years have reached out to take the opportunity to note in opinions that weren't opinions of the court, that they kind of volunteered to inject their views on, and opinions that denied certiorari of First Amendment cases. So these are instances where the Supreme Court declined to review a case, and Justice Gorsuch, Justice Thomas dissented from the denial of certiorari and opined on what they now think of that 50-year-old precedent, Times versus Sullivan. And I think a bit of a canary in the coal mine here maybe, but what they've said about the viability of that precedent and the underpinnings of that precedent should cause deep concern for anyone in the business of satire, parody, or other First Amendment work.
So I think I'd like to pick up with that thread. Let's turn to Shawn for a minute and talk a little more about how he helped Nicholas and about what a cartoonist or satirist can do when they're faced with a situation like this. And then Roslyn, I'd like to follow up with you a bit more about the potential for the Supreme Court to take a darker turn in the future. So Shawn, say a cartoonist is faced with one of these kind of threatening, maybe not a lawsuit, but threats of legal action. What is the first step I should take if this happens to me?
So now it's my turn to give a little bit of a disclaimer, as Nick did, which is that I can't give legal advice since I am still waiting on my bar results in November, because that's how long California takes from July to November. So I'll limit my response sort of to what I learned from helping Nick, which I do think might be common to what other people do, what cartoonists, anybody who's faced with kind of a BS claim, and I feel like I can say BS because I looked through the transcript this morning from Hustler, Rosalind, and I saw that the Hustler attorney used awesome language that I never expected to find in the transcript. There's audio online, and it's really wonderful. Yeah. So BS claims are going to come. I see that. So I work now with investigative reporters. And in the reporting community, we're just as worried, Rosalind, about New York Times v. Sullivan going away. There are cases percolating up from Sarah Palin, for instance. I think the court is really going to take one soon. But to kind of the ground level instances where somebody is threatening a satirist, I think the first thing is just to talk to somebody who knows what they're talking about. Stanford should have known better. They they suggested that at least one lawyer had looked over the poster that Nick sent out, and it kind of passed their initial sniff test for protected speech, which is scary that a lawyer could look at it and kind of apply a really quick First Amendment test and see see if it wasn't protected. This is much easier than a lot of the examples that we went through in my First Amendment class. They're not anywhere, Nick's flyer wasn't anywhere near the line. So even if a lawyer sends you a scary letter, that doesn't mean that they did a good faith job, especially if they have a pretty well-heeled client that they're trying to represent. An attorney might send you total BS in terms of a letter. So unfortunately, the first thing that Nick and I, or I guess the second thing after just trying to talk some sense into the administrators, was reach out to the First Amendment community. Luckily, FIRE, the organization that Nick mentioned before, is set up specifically to protect the First Amendment and free speech rights of both students and staff, and faculty in higher education. They sprang into action immediately, including because Nick's flyer was so funny that they kind of smelled the Streisand effect coming, as well as just because they could just write such an open and shut case around it. So we found those resources, and Roslyn may be able to speak to resources that are available for people who are not in school. But I think that was just the first thing that we did, was we just kind of contacted as many lawyers as we could to see if to get our bearings, to see if what Stanford was doing made any sense, and just kind of run through on a practical level what our next steps should be. I wouldn't represent going up against lawyers like Devin Nunes had or has currently, bumbling as they are, on your own, unfortunately. Yeah.
One quick resource I'll mention is the American Bar Association has a forum committee on communications law, which is comprised of hundreds of First Amendment lawyers from law firms, large and small, around the country. And there are many law firms that, as mine did, that would take on a First Amendment case pro bono. I mean, my representation was pro bono all the way through. And so that is a first place I would consider, in addition to a law faculty members who teach the First Amendment, who have access to students who can help them. But I think Shawn's right. There's no doubt these cases are percolating in the lower courts, and it's inevitable that there's going to be a district judge, a Court of Appeals judge, who's going to write a decision that speaks to Justice Gorsuch, Justice Thomas, and other justices, and going to persuade them to take a case where they can re-examine Times versus Sullivan.
Roslyn, can you explain just a little more of the background of Times versus Sullivan and how that would actually threaten cartoonists if they did revisit that?
Sure. So before 1964, there were 50 state laws on defamation with different, some similar, but some different elements in order to sustain a case. Times versus Sullivan in 1964 constitutionalized the law of defamation, so that you wouldn't have a situation where you could sue in Vermont and get one result, and sue in California and get another result. And the court decision, which was unanimous, said that the First Amendment demanded that there be a universal standard, making it very, very difficult for public officials to recover for defamation, that the First Amendment required that in order to promote uninhibited and robust debate on public issues. That case was extended over a number of cases in the ensuing years to public figures, not necessarily public officials, who are core protectees in the Supreme Court's view. And extended even further to this concept of the limited purpose public figure, someone who may not have always been a public figure like an athlete or an actor, but someone who injects himself or herself into the public arena. And that is what brings me, if I can spend just a couple minutes before we finish, on these two worrisome opinions. So in 2019, a woman named Catherine McKee sued Bill Cosby for defamation. She had accused Cosby of rape 40 years earlier. Cosby's attorneys responded with a letter that Ms. McKee claimed was defamatory, and she sued in Boston federal court. The district court dismissed the case, finding that McKee was one of these limited purpose public figures. The First Circuit affirmed, and the Supreme Court denied certiorari, decided not to hear the case. So this is one of those two decisions that is just blinking red for all of us who care about protecting satire. Justice Thomas said, the bottom line is that from the beginning of the Republic until 1964, the states were fully capable of protecting the reputational interests of their citizens. And the court just created this policy judgment, or just made a policy judgment that the First Amendment should supersede those 50 state laws. And so it created this broad protection that is nowhere grounded in the founders' thinking. So that was his view at that time. Then 2 years later, in a case, another defamation case, an individual sued a book publisher after being described as a member of a key figure in the Albanian mafia. So he sued in Florida federal court, and the court threw out the case saying that he was a public figure and had not satisfied Times versus Sullivan. Justice Gorsuch, so Justice Thomas also dissented from the denial certiorari, citing many of the things he said in the McKee case, the Cosby case, but Justice Gorsuch had a very different tack, and his tack is really something everyone who's listening and who cares about Times versus Sullivan should read both decisions. Justice Gorsuch said that the media landscape that was present in 1964 when Times v. Sullivan was decided has completely changed. That it's almost quaint to talk about an editor in today's Twitter world. It's almost quaint to talk about the time it takes to scrub and publish a story that's fully accurate. That anyone can generate news, and anyone is a publisher without any filters, without any editorial standards. And that because the media landscape has changed, the Times v. Sullivan standard should be revisited. He doesn't say it should be reversed. He's careful to make a kind of academic argument that the groundings, the foundational facts that existed in 1964 no longer exist. And what he said is that the statistics that show the vast majority of libel cases are thrown out by the district courts, and if not, are thrown out by the courts of appeals. He said the statistics show that Times v. Sullivan has become, quote, an ironclad subsidy for the publication of falsehoods by means and on a scale previously unimaginable, unquote. And he cites an Ohio Law Journal article that begs for talented lawyers like Shawn and Nicholas to write the rejoinder to. He cites an Ohio Law Journal article that depicts or makes a really strong case for why the media landscape should change the Times versus Sullivan broad protection for public figures. So there are lots of things that AAEC and other champions of the First Amendment should be doing. That's for another day, but these arguments need to be met head on in the lower court cases that could be bubbling up. And ultimately, when the court takes a case, they need to be met head on because they're both very serious ways of challenging the underpinnings of Times versus Sullivan.
Nicholas or Shawn, do you have any further thoughts on that?
I mean, one thing that I'll point out is that one of the interesting things about my case, and one of the reasons it got so much attention, is because the Federalist Society is an organization that is traditionally associated with kind of a strong pro First Amendment stance. And there are a lot of kind of First Amendment defenders who have been associated with the Federalist Society in the past. So it was kind of absurd and ridiculous to see the Federalist Society themselves just like totally throwing the First Amendment under the bus to attack someone who had made fun of them. But I think it reflects an actual shift that's happening in conservative legal thinking. And the Federalist Society elsewhere has been holding these debates about Times v. Sullivan itself. And it's like one of the things that they're kind of batting around right now is like, actually is the originalist position on the First Amendment, like, does Times v. Sullivan like fit within the originalist position on the First Amendment? So there are signs that this shift is part of the broader conservative legal movement.
Yeah. I would just add two things. One, for Roslyn, I'll send it to you after the talk, and if any of the cartoonists here would like to read a law journal, I would encourage them to at least skim it. There is actually a really wonderful article that just came out in, I believe, the Louisiana Law Journal, from a great attorney in the Communications Law Forum, Matt Schaefer, who's at CBS Viacom, looking at the originalist arguments, and particularly at the early law of libel, particularly differentiating early American libel law from England, and particularly trying to address some, I mean, it's aimed squarely at Justice Thomas's arguments, and kind of at the implicit ones under Justice Gorsuch. Someone should make a cartoon of it, perhaps, in order to simplify it, because it is a very long, winding argument as original. And that's not to fault the author of the article. It's kind of maybe to take some shots at originalism generally, but that's for another conference.
One wicked thing that Justice Gorsuch did in this Albanian mafia case is he cites Elena Kagan's review from 1993, many years before she became a justice of the Supreme Court. But she asked some very astute questions and made some very interesting and trenchant observations. And back in '93, before social media took over the world, about the underpinnings of Times versus Sullivan. And I think it was a nice little needle by Justice Gorsuch to cite her book review from 1993.
Yeah, I agree. It was very well aimed. I love when the justices kind of trade citations to each other's work that support their argument, even if it's very narrowly. The other thing that I just wanted to really hammer home on Roslyn's point of before New York Times versus Sullivan, each state handled defamation differently. I think that the Nunes cow case and similar cases where plaintiffs shop from state to state in hopes of finding one that's in hopes of finding a court system that's more amenable to their claims, including where they clearly, I mean, Devin Nunes as a congressman is clearly subject to the heightened legal standards of New York Times v. Sullivan. I don't even think his kind of bumbling attorney has tried to argue otherwise. But what he's done is hop from state to state in filing not only the Nunes cow litigation, but also several other cases to inflict maximum damage just by shopping from court to court. And so since New York Times v. Sullivan imposes, or rather, even with New York Times, even with the current protections that we have in place, plaintiffs are already allowed to take advantage of differences among the states. And so what getting rid of New York Times probably do the most damage to, honestly, is the procedural things, is making it harder to get rid of these suits quickly, because then lawyers need to be prepared to handle arguments in multiple different states, coordinate across state lines, and then argue about what state the case is supposed to be. And these sound like minutia. These sound like really, really small things, but that's where the money comes from, in that plaintiffs, defamation plaintiffs, lawyers use to bleed. It's what he's done, what Congressman Nunes has done to Devin Cow and other defendants, including freelance journalists. And it's what would be even easier to do without the Sullivan standards.
Yeah, and let's go back to the point that Jen asked earlier. The fact that a libel plaintiff may not win ultimately after many years of litigation does not mean that it will exact an enormous cost on the publisher and on the individual publisher, whomever the employer is, over those years, not only in the expensive litigation, but in the so-called chilling effect, which is very real, from discouraging publication of, hard-hitting satire. Let's not forget that cost. And I think it's most likely that the court will nibble around or take big chunks out of Sullivan rather than reversing it. It'll constrict who is a public figure or a limited public figure. It'll perhaps, I'm not a prognosticator, nibble around the edges rather than just wholesale reversal. That's what Justice Gorsuch hints anyway.
Hey, I just want to jump in here real quick. Say you got about 10 minutes left. I saw there's some Q&A there, but just a quick reminder on the clock.
Okay, so in the limited time we have left, I wanted to maybe lead off the questions with one of my own. I know that the Freelancers Union has written about this, about like liability insurance for writers. And I was just curious whether you all think that there is some merit in freelancers taking on a liability policy that would at least help with one of these long drawn out cases which would be a money suck and a time suck, if not like, even if it didn't actually end up with the satirist losing the case.
Well, that's an important question, and I'm afraid I'm a little out of date on professional liability insurance, which sometimes can exclude intentional torts, and defamation is an intentional tort. So the standard policy might exclude it, but I know there are products in the marketplace that would cover certain liability, but there are people who are experts on this, and I'm not one of them.
There are products for writers and satirists now. I mean, I think it's sort of a recent development, but just interested in, I think it's very new actually. And so I was just wondering if any of you have ever dealt with that or have any familiarity with those policies.
So I was a freelance reporter for several years before going to law school. And in retrospect, now that part of my job is to defend against defamation claims, I am kind of scared retroactively that I didn't have some sort of insurance. I mean, some of the contracts that I read at the time with publications where I was published specifically kind of made me take on sole responsibility in the case of a defamation lawsuit. So the publication, many publications now do have their own insurance policies for libel and defamation cases. And if they're feeling like they could always decide to include you in as part of the defense if you're both named, but they could, under some of the contracts that I signed, they could choose not to. And so, I mean, again, a plaintiff, a defamation or libel plaintiff who's looking to send a message rather than, and isn't necessarily after money, can go after freelancers rather than going after the publication. They can always go after both if they're interested in both, I guess. But like it does kind of, again, like I never shopped for them, so I don't know how expensive they are or how workable, particularly that is on a freelancer's budget. But now on the legal side of the fence, I wish I'd at least looked into them, because I was writing about, I was never doing cartoons, but I was writing about people who my research indicated had committed some sort of misconduct, particularly government figures. And so I was definitely exposed. I just didn't necessarily realize it at the time.
Right. I believe that the Freelancers Union does have some policies, and we were going to have someone from the Freelancers Union on the panel, but that didn't work out today. But they, if you want more information about that, you can go to the Freelancers Union site and
That's great.
Check that out. I guess we have a couple minutes. Let's look at the questions here. Gretchen asks, can they talk a little more about the legal definition of parody and what kinds of media and content that applies to? It's an excellent question. Does anyone want to take that on? How do you define parody?
I knew the legal definition of defamation about a month ago when I took the bar exam, and then I forgot it. So parody, it's a different question. Parody is obviously something different.
Yeah, Roslyn, is there really a case of defining parody? It's more about it's more about whether something made a factual claim. It's not really, as I understand it, it's not really about showing that something was satiric or a parody of something. It's rather kind of the same as in the Hustler case. It wasn't the justices were never interested in saying in ruling this was parody. It was kind of the flip of it, which was this was not making a factual claim.
That's right. It's more what parody isn't than what it is that the court focused on. And what it isn't is something that a reasonable reader would recognize as a false statement of fact. Now, the courts that have looked at parody cases look at the context of the publication. So sometimes parodies have disclaimers, right? Like we saw in the Hustler parody. Sometimes they're published upside down. Sometimes they use hyperbole, something that a reader would immediately recognize as something that isn't serious. There are cues, and this applies in the Twitter marketplace too. And some of the law journal articles that talk about parody on Twitter talk about how to safeguard First Amendment protections by having those who are publishing these parodies use some of these cues deliberately to alert the reader that this isn't asserting a statement of fact. So I think it's important, in future AAEC workshops and discussions that you perhaps look at those, not to create any timidity, but to just be aware of these contextual legal arguments that will be made in the event some parody is taken to court, that there are cues to the reader that the practitioner can have in mind to at least strengthen the case that this would be clearly recognized as parody and not a statement of fact.
Hey, this is JP. I just want to jump in quick because Zoom won't let me actually post a Q&A in the Q&A button for some odd reason. But following up on that, do you think that some of the propaganda sites, the fake news sites put up by bad actors, and for instance, especially leading up into the 2020 election, where somebody posted something that was clearly a falsehood, and then when they were called on it, they said, "Oh, it's a parody. It's a parody." Do you think that might, one, can they claim that it's a parody after the fact? And two, do you think that they might get hoisted on their own petard once, if Sullivan were struck down, because, oh, you claim parody now, well, you're not protected anymore?
Well, yes and yes. No, anybody can claim it's parody after the fact, even if they don't label it as such or use any of these techniques to alert the reader. But yes, I do think there's a real danger. That there was a case against former President Trump by someone who had accused him of sexual misconduct, and in response, Trump claimed that she was hired. She was a campaign worker who was hired initially and couldn't cut it, and so she got angry and I made some other false statements about her, that she begged us to hire her, and she claimed for defamation, and the court said no one would believe that was true. We all know that that former President Trump exaggerates, and politicians exaggerate a lot, so no one would have taken that as true, that she begged to come back to the campaign. So these claims of parody can be made after the fact, and I think in the right case. And some of these profoundly disturbing disinformation cases, that one of these is going to go into the courts and be seriously challenged in a defamation claim or infliction of emotional distress claim or invasion of privacy claim, and put everything on the line. And it'll be like, if Times v. Sullivan were revisited, it's going to be like living in a world where there's no gravity. It's going to be that serious change in the landscape. And it may come in small pieces, or it may come in big chunks. We don't know.
On that note, I think we are out of time, are we not, JP?
Yeah, we have like a minute or so to wrap up, but I mean, that dire note, I think, is a really good one.
It's a good note to end on. As much as I actually, I could keep talking about this for an hour. I think it's a super interesting discussion, and maybe we can revisit it again next year. But I'd like to thank our guests again for coming, and I just think this is super fascinating, and it's an honor to have you all here. I guess we need to clear out of here, because Keith Knight is going to be coming up with his talk about Woke, his series on Hulu. And Keith made a little appearance at our Zoom chat last night, and it was good to see him. And I think that you're all in for a real treat coming up at 6 p.m. Eastern. All right, well, thank you all, and really just great panel. And,
thank you all very much.
Thank you so much. It was so much fun.
Courageous.
Take care.